The Supreme Court is now in session. The Honorable F. Philip Carbolito, Chief Justice presiding.
Good morning, councils. And at this time, I will ask the clerk to please call the case.
This is Supreme Court case number CVA 19-025. Juan P. San Nicolas and John J. Sablon, petitioners appellants, versus Edward Byrne in his official capacity as the Director for the Department of Administration, Respondent Appellee, and Guam Fire Department Real Party in Interest Appellee. Appearing for the petitioners appellants is Attorney Jacqueline Taitano Terlahi. Appearing for the Respondent Appellee and Real Party in Interest is Attorney James L. Canto. The panel consists of Chief Justice F. Philip Carbolito, Associate Justice Robert J. Torres, and Associate Justice Catherine A. Merriman. Attorney Terlahi reserves 10 minutes.
Thank you, Madam Clerk. At this time, Attorney Terlahi, you are recognized.
Buenas and half a day. May it please the court, Chief Justice Carbolito, Justice Torres, and Justice Merriman. For 20 years, firefighter Juan San Nicolas and firefighter Sablon have asserted the rights afforded to them under Guam law. After 20 years and after two separate writ proceedings, an administrative proceeding before the Civil Service Commission, a desk audit, and a judicial review process in the Superior Court of Guam, they finally sought from the Superior Court the second writ, which is the subject of this particular appeal, which is to find that they hold permanently and should be promoted to a fire specialist position pursuant to 10 GCA section 72107. What's extremely important in this case is to remember that these firefighters did not put themselves in a temporary position in excess of 5 years. It was the Guam Fire Department who assigned them to a position in the Fire Prevention Bureau. The lower court, when it made a determination, a factual determination that firefighters Sablon and San Nicolas did not occupy the position of fire specialist, the lower court abused its discretion. It abused its discretion for two important reasons. The first is because there is a res judicata doctrine application in this case. As I set forth in the beginning, in this case, firefighters San Nicolas and Sablon sought review before the CSC, sought review before the Superior Court. When those particular avenues were foreclosed to them, they sought a writ of mandamus, which was granted to them. Following 15 years of litigation, firefighters San Nicolas and Sablon lost their determination at the CSC. They initially sought to be held to the position of fire captain. It was the Civil Service Commission who made the factual determination that they did not perform the duties of fire captain, but that they performed the duties of a fire specialist. As a result of that finding at the Civil Service Commission, the firefighters then sought the ministerial act of the Department of Administration to perform its obligations as set forth by 72107. Only at that time.
If I may interrupt at this time, the Superior Court, you raised the issue of res judicata, which is a substantive issue that, at least in my mind, that is before us. And so in the first case, in terms of SP 189, SP 0189-10, when the trial court held that the petitioners in the first writ case were not entitled to be to the position. In that first case, the petition was that the firefighter won your clients. They felt that they were entitled to a captain position. And so that was litigated and that proceeded. and you were seeking at that time compensation for your clients. They were seeking for services performed that were in excess of the firefighter one position. And there, both DOA, civil service said that that was not justified. And although they then described that they were performing other duties, which was the fire service specialist position. So the issue of compensation and the issue of that your client was being assigned to a position other than a firefighter one position. So that was litigated, and as if that was not a satisfactory resolution, why couldn't or why was an appeal, let's say, of that case not pursued that could have then brought this issue and avoided this res judicata issue that we now have before us?
Well, Your Honor, in that particular proceeding, the SP 189-10, you're absolutely right that the issue that was being presented to the trial court was whether or not the Civil Service Commission had abused its discretion in failing to hear the merits of the claims of the firefighters. And so in order to get before the Civil Service Commission on their grievance and on their desk audit review, the firefighters had to pursue the writ of mandate at the Superior Court. Following that determination, the CSC made the specific factual finding that the firefighters were performing as fire specialists. And so that would be an appeal of the CSC determination. So the CSC determination was in fact that they performed fire specialists. The firefighters did not pursue a review of that particular determination, and neither did the government. So when we proceeded back to the court in terms of the writ of mandamus to ensure compliance by the CSC, it was that at that time that we believed that 10 GCA 72107 would be applicable, because for the first time in the 15 years of litigation, there was a factual determination that they were in fact fulfilling the duties of fire specialists. As a result, 10 GCA 72107 became applicable. Had the firefighters won at the CSC level on the fire captain position, then they would not be entitled under Guam law to this particular provision. So it was only after the 15 years of insistence of the rights granted to them under Guam law.
I know hindsight's always easier than foresight, but at the time that there was this ruling that the two firefighters were performing the duties of a fire service specialist, and that was the Civil Services Commission's findings. I mean, then couldn't the writ have been to mandate that they be paid accordingly? Number one, if the statute had not come to anyone's attention at that time, at the minimum, in terms of the compensation issue, couldn't that have been determined at that first litigation in terms of SB 189-10?
Under the fire captain issue, Your Honor, you're absolutely correct that the Superior Court could have reviewed the issue had there been an appeal of that particular issue, but there was no appeal of the CSC finding. What was before the court in SP 189-10 was whether or not the CSC had complied with the writ of mandate to hold a hearing to determine the factual basis, which was whether or not the firefighters were performing either at a fire captain position or at another position. So at that particular moment, there could have been no review of the determination of the CSC since neither party sought to review the CSC finding. What was before the Superior Court was a mandamus for the CSC to make factual determinations. And so because neither party pursued that at that particular moment, that is an issue that would not have been before the court.
Mr.
The
Lahi,
government, go
didn't
ahead,
you
go ahead.
wait until after both plaintiffs were no longer employees of the government to seek this relief?
No, Your Honor, that would be incorrect. The employees, in fact, have been employed with the government. Throughout this process, there has been some gap of service as a result of resignation in good standing. Both firefighters at some point in their careers in the last 20 years did in fact leave government services for a short window, but then were re-employed by the government under their good standing basis, under the laws providing protection for them. So there was a separate action in which firefighter Nicolas was in fact re-employed with the government at a step less than authorized by Guam law. And he took that matter before the CSC and he prevailed. So in essence, neither firefighters have had essentially a termination from government. Both firefighters are in fact current employees of the government of Guam. And so their issues on the writ of mandamus, we believe, are still preserved.
We didn't have the benefit of a reply brief, but the government mentioned the statute of limitations issue. They specifically stated there were 3 different limitations that were not complied with. The 7 GCA 11305A, that civil actions have to be brought within 3 years. The personnel rules of DOA that talks about seeking review of a reclassification within 20 days. And the appeal with the CSC within 15 days after receiving the classification decision. Why aren't those statute of limitations applicable here?
None of those statutes are applicable to these circumstances, Chief Justice Torres, as set forth by Chief Justice Carbolito. Hindsight is always much better. In this particular instance, we weren't aware that the CSC was going to make a determination that they were not performing and occupying positions of fire captains. So only when the CSC made its determination that they were in fact occupying and performing duties of a fire specialist, that's when the calculation of time would become appropriate under any of the statutes. In this particular instance, the CSC made its determination sometime in November of 2015. The firefighters immediately made a demand to the Department of Administration within a short window of time to seek redress and request that Department of Administration comply with its statutory obligation based on the CSC determination. Following that CSC determination, the Department of Administration denied their statutory obligation, which compelled a request to the SP 189-10 and a request for a secondary writ proceeding, an alternative writ to be issued out of that court because it was related to the same type of matter, the same parties. In that particular proceeding, the Superior Court declined to issue the second writ, but held that it was appropriate for the petitioners to seek a different writ before a different court. For whatever reason, that was what the decision was of the Superior Court in SP 189-10. Neither party appealed that particular determination, and we pursued the secondary writ in a second proceeding, which is the current action before this court, following the orders of the Superior Court in that first writ case. And so as a result, we end here in this particular court pursuant to the writ process. And the government has asserted that there is some type of violation of the statute of limitations, but we did not have a determination that those firefighters were in fact sitting in the position of fire specialist until at the earliest November of 2015. At that time, the process of the writ, the process of the demand was in fact invoked pursuant to the statute.
But as the government points out, Attorney Terlahi, in reference to the first case, SB 018.10, although the the Civil Service Commission's finding or decision was that the firefighters were performing duties as a fire service specialist. Since that was the decision, and the writ that was taken as a result of after that ruling, the government points out that it could have been raised that with that conclusion, that then they were entitled to the benefits of 10 GCA 72107. And as the government points out and cites the authorities, not only is it what was litigated, but what could have been litigated as a result of the facts and claims that were made in the original claim. And here it's for the firefighters were saying that they were not being properly classified, and correspondingly, they were not being compensated appropriately, and they're entitled to back pay. And so with that's the claim. And although the legal theory may be a little different, that doesn't change the res judicata elements, that it's not only what the issues were that were litigated, but what could have been litigated as a result of the facts and circumstances surrounding the original claim.
And Your Honor, what you have in SP 189-10 is the Superior Court of Guam holding that 10 GCA 72107 was not within that particular writ of mandate process, that court had not considered that issue, and the court was not going to consider that issue because it did not feel that that issue was before it. And hence the result of that particular court proceeding, which was that it would be appropriate for the petitioners to seek a second writ of mandamus before a second court and not before that court. So the determination of, or the action of the petitioners basically was consistent with the order of the trial court, that it was declining to address that particular issue, and that it was not appropriate within that first mandamus to address that issue, that it would be more appropriate for a second mandate to issue. Hence, the parties did not appeal that determination. Neither party sought an appeal of that finding, and both parties proceeded before the second writ case. And in the second writ case, that was the sole issue before the trial court, was whether or not 72107 was in fact applicable. And what's important in this case, Your Honor, is that what we had before the trial court by that point, after 15 years of litigation, were certain admissions made by the government. The government made admissions in its answer.
Let me ask this, if I follow you then, Attorney Terlai. You're saying that the reason why 72107 was not raised was because the trial court in the first proceeding in SB 189-10 was saying that to raise that issue, you had to file a separate writ. And so you followed the trial court's instruction. And when you did that, you're saying that the court is now saying, well, it's res judicata because, you know, it could have been raised in the first writ. So is that what you're saying happened here?
Essentially, Your Honor, that's exactly what happened in these proceedings. It's why the reason why we are before the court on the second writ is simply because the first court did not address it and felt that it was not within its ability to address it because it was not the issue before it. The issue before it was whether or not the CSC had complied with its obligation to make a factual finding. So the second issue under the 72107 was whether or not DOA had an obligation to fulfill ministerial its duty. And so the court at that time said, well, the first writ was whether the CSC had made a factual finding. We've given you that. And so we're done here. If you want to ask the court to make a finding about 72107, you've got to file a second action. And that's essentially what we did. I mean, the alternative that the court did set forth is that we could either seek a second grievance or an additional grievance because this had followed 15 years of administrative process, or we could file the second writ. We chose to follow the court's suggestion and filed the second writ in this particular case.
When the court made its decision that the request for a writ is appropriate in a separate action, they made a finding that the request in the renewed peremptory writ was different in the claim and relief than what was initially requested in the first verified petition. But the court didn't, in its ruling, say that any defenses to bringing that separate writ were not going to be effective. And the question that I have is, when you brought that first writ, you were looking at the duties that the firefighters were performing beyond their firefighter one duties. And so that issue is the same issue in this case. Similarly, the right that's at issue, their right to be promoted for performing extraordinary duties, seems to be the same issue. They seem to arise out of the same transactional nucleus of facts. What facts are different in the second peremptory writ that's different than the first?
The major fact that is different is that we have a factual finding by the Civil Service Commission that the firefighters were performing as fire specialists. As I alluded to earlier in the argument, had the CSC found that they were performing as fire captains, we would not be before this court. The reason why the lower court in SP189-10 made a determination that it was a different issue was because the different issue is the ministerial obligation of which body. In SP189-10, the ministerial obligation that we were arguing was the Civil Service Commission's obligation to make a finding of fact. In this writ of review, we are asking the court to find that the writ of mandamus was appropriate because the action below was specifically about whether or not DOA had performed its obligations under the statute. Two different entities may arise from the same set of facts, but the ultimate fact that made the change to lead to these proceedings was a determination of fact. That fact was that the firefighters were performing as fire specialists on a temporary basis for more than 5 years. That's where these particular firefighters were drawn into this statute, which granted them the right to promotion, which was a new right that was established by statute. So as a result of the CSC's determination, this particular statute became applicable to the firefighters.
So you're saying there's not an identity of the parties? In one case, it was the CSC, and in the other case, it's the Department of Administration? That's your belief as to why res judicata doesn't apply, because the identity of the parties or their privies in the separate actions are not identical?
Well, Your Honor, technically speaking, the Department of Administration with GFD were parties in the civil service proceeding. And so I can't say that they weren't involved because they were jointly represented by the Office of the Attorney General. So the thing is that the identification of the issues is essentially the difference in these particular cases. In one case, it was the factual determination of whether or not the firefighters were performing in job 1 or job 2. We were advancing the theory that they were performing as fire captains. We failed at that particular process, and it was the CSC who made the determination that they were not performing as fire captains, they were performing as fire specialists. So as a result of that determination, a new obligation was imposed on the Department of Administration by 10 GCA 72107. As a result of that finding of the CSC, DOA then was compelled by Guam law to promote ministerially these two firefighters because there was a finding that they had been performing in the fire specialist position in excess of 5 years.
And that's where I have a little problem, Attorney Terlai, is when there was that determination that the firefighters here were performing as a fire service specialist. Within that action, although there was this writ that commanded them to make this, have this hearing to make a determination. And once that determination was made, I don't understand why that SB 189-10 couldn't be used to mandate the corresponding action that you now argue in SB 88-17, that and that there was a separate action to then command an outcome as a result of a finding within 189 or a decision of 189-10. And that then provides the opportunity for the government to argue that the 189-10 could have been utilized to carry out the actions and the entitlements that were found as a result of the Civil Services Commission's decision by then commanding DOA to execute the necessary personnel actions such that the firefighters should have been either paid for their additional services or promoted, as you now argue in 88-17. And because there was a final determination in 189-10, the issues could have been raised that as a result of the findings in 189-10, DOA had certain ministerial duties to then execute those personnel actions under 72-107. And because that was not done, this gives rise to the government's argument that the case, it's, res judicata bars the SB 88-17.
And the one thing I would raise in response to that question, Your Honor, is the fact that there was no determination on this particular issue. The lower court did not make a final determination in any of the proceedings on the applicability of 10 GCA 72-107. It was only within SP 88-17 that there was a determination. That is where I think that the res judicata application, when you look at the issues before the court, whether or not that issue was addressed, that particular issue was not addressed by the other court.
But it could have been addressed if it was properly raised in 189-10.
And the lower court determined that that was not an issue within that first writ, hence the order to pursue a second writ. And so rather than appeal that determination, we followed the lower court's order.
But I guess the question isn't, was it determined in that first one? Could it have been determined in that first one? Could it have been raised? I mean, and that's the troubling feature for us, is that if this is an issue that the causes of action could have been raised in the earlier and the later suit, there's an identity of the parties and a final judgment on the merits in the earlier suit, those seem to satisfy the elements for res judicata.
And Your Honor, again, as I said, while it could have been raised in that particular proceeding, the lower court made a determination that it was not within its jurisdiction under the writ of review process, because the court made a finding that what was being addressed on the writ of review was the action of the CSC. That was the confines upon which the first writ proceeding was a determination being made. There was no determination in that particular case of whether or not DOA had performed its particular duties. Your Honor, I don't know. I'm not sure about the clock. I'd like to ask.
Your time remaining is 8 minutes and 26 seconds, right? So you've reserved 10 minutes and it's gone less than. So if you want to reserve the remaining time at this time.
Yes, Your Honor.
All right. And so at this time, I'll recognize Deputy Attorney General Jamie Canto.
Mr. Chief Justice, Associate Justices, and may it please the court, respondent appellee DOA and real party in interest GFD would respectfully urge the court to affirm the lower court's finding and holding and decision in SP 88-17 for several reasons. And the first being the res judicata issue, which has been raised quite a bit by the court just now. The fact that the CSC did enter or render a final judgment on the merits, that there was an identity of issues and identity of parties. And alternatively, as has been pointed out by the court, the issue regarding 10 GCA section 72107 could have been raised at the CSC level. And this is where I think there may be a miscommunication between counsel and the court on this issue. The reason that the trial court in SP 189-10 said that it had no jurisdiction to hear the argument being made under section 72107 at that time was because petitioners did not exhaust their administrative remedies on that issue below. And so that issue should have been brought to the Civil Service Commission. But however, the petitioners flatly rejected that finding by the Civil Service Commission, that as the court in, I believe, 189-10 pointed out, if not SP 88-17, that petitioners, once the CSC found that they were performing duties at the level of a fire specialist, the petitioners rejected that, seeking to be compensated, if not promoted, as fire captains. And so that issue was crystallized at the CSC level, and the petitioners did nothing to go back and exhaust their administrative remedies to ensure that there was a waiver of sovereign immunity so that the court in SP 189-10 could be able to hear that issue that they would be advancing. And that could have taken the form of a grievance, which would have been the proper course. But that's another reason why the lower court's holding should be affirmed, and that is in terms of the statutes of limitations violations. 3 of them that were violated by the petitioners in the case. One, starting with that 20-day statute of limitations imposed by DOA Personnel Rule 5.014D as to when to bring the issue forward to DOA for the desk audit. They waited 4 years instead of 20 days. Then, once they received the determination by DOA that talked about compensation as opposed to promotion, the petitioners should have, according to DOA Personnel Rule 5.014F, have appealed that determination to the CSC within 20 days. Instead, they waited 14 months and violated the second statute of limitations that would apply to them in that regard. And then third, even as the trial court pointed out, the statute of limitations in 7 GCA section 11305, which is a 3-year statute of limitations to bring the issue before the court because of an obligation created by law, they failed at that as well in terms of SP 88-17, which is the case before this court currently. And they violated the statute of limitations to come forward and file that case, even though they were instructed by the, as counsel submits, that they were instructed by the trial court in SP 189-10 to file another writ. They didn't do that within the statute of limitations for doing so. Even the court in SP 189-10 gave them great latitude and benefit of doubt to say, well, because it was a continuing violation, they were finally promoted in 2008, they would have had 3 years from that time to file an action in Superior Court. Instead, and that's why the court in SP 189-10 entertained it, because that was in 2010. So even by that argument, their ability to come before the court would have lapsed in, at the very latest, the end of 2011, beginning of 2012. However, the petitioners did not come forward and file an action that is before the court currently until more than 5 years later in 2017. Another reason why that statute of limitations was violated, and the reason for which the action before the court now should be affirmed in terms of the lower court's holding, if for not that reason alone. Another reason why we asked the court to affirm the lower court's ruling applies to the failure to exhaust administrative remedies on behalf of the petitioners, as I've explained somewhat, and which do connote jurisdictional problems as statutes have proposed because of the necessity for waiver of sovereign immunity to bring this suit. And I don't mean that in terms of a drive-by jurisdictional ruling, as this court noted, say, in Castillo versus GC Corporation, because it is a suit against the government for which, of course, the waiver of sovereign immunity must be express, only made by the legislature, and strictly construed by the courts. And those would have included filing that grievance before the Civil Service Commission on the issue of 10 GCA section 72-107. If not, to move the Civil Service Commission to reconsider its decision, or to file for an administrative review of job classification, which is what the lower courts have found is really at issue here, that they're seeking job classification redetermination for an actual promotion, as opposed to being compensated for performing the duties of that position. Also, the 10 GCA section 72-107 simply does not apply to the petitioner's facts. The petitioners in their opening brief go to great lengths to say that somehow the Civil Service Commission found that they had occupied the position of fire specialist. And though those key words, occupied the position, are repeatedly used by petitioners in their brief, because they know that that is the operative language of the statute 72-107. And they can't advance their case without applying the facts in that regard. The problem
Don't
for
you
them,
think someone serving in a position for 5 consecutive years is occupying that position?
no, Your Honor, with all due respect, it's simply performing the duties. Now, to be able and say that somehow, if you just perform the duties of a job, that you have, you should be given the job itself, would subvert the Organics Act's requirements under the merit system for competitive hiring, first of all. And I don't believe that a court could circumvent that requirement.
But couldn't we interpret it in a way to reward an employee who's performing the work of that position to which he wasn't promoted or appointed? I mean, if you're expecting that he's doing this work for the 5-year period, then it seems that, you know, there should be a basis. And, you know, it's not like the court had indicated an unexpected spring, because, you know, you've got the employee performing these duties for 5 years.
Right, and the reward, Your Honor, is the compensation. They're compensated for their extra duties. Now, what's important to this analysis is that the trial court acknowledged, and petitioners do not dispute, that there was no evidence of a formal appointment or temporary appointment. And under other law, of course, that could not extend past 90 days anyway. But here, the petitioners could have easily have stopped doing that work. They did not. They chose to continue to do it in the hopes of being recompensed in some fashion. And they were. The CSC found that they should have been, and that was in terms of being compensated for the extra work they were doing outside of their job title. And they were eventually promoted in 2008, which resolved the problem altogether. But just because they have done the work does not mean necessarily that they are now in that position or become the position for which they have done some work. Because if you remember their initial...
Let me just ask this, Mr. Cantor, because you seem to be suggesting that the department should not bear any responsibility to the employees, and they can expect performance, in this case, a firefighter one performing a fire service specialist position, and tolerating that for a period of over 5 years without any formal appointment, because I assume that that would run afoul of for GCA 4117, not compensating them, but expecting them to perform these additional duties. That just suggests then that the government is saying it's all right for the department not to bear any responsibility for requiring this additional work without compensation and without any expectation of promotion. Is that really the circumstance here and what you're suggesting?
No, Your Honor, with all due respect, not at all. The government, they worked certain duties for 4 years before bringing it to anyone's attention. They could have easily have not performed those duties, and they would not be subject to any adverse action because those are not duties within their job classification. They waited, instead of within 15 days of that issue, raising it and seeking a job reclassification of their own, if that's in fact what they wanted, not just to be paid to do that work, but to be elevated to the position that they didn't compete with anyone for just by virtue of having done the work. They could have done that within 15 days and instead waited 4 years to bring it to anyone's attention. Now, they could have not done the work. They could have sought job reclassification, and they didn't do any of these things. They instead sought 4 years later to ask, when they eventually appeared before the CSC, more than 4 years later, asked to be promoted to fire captain from firefighter one, when they had not done any of the managerial or supervisory duties that are inherent to a fire captain position, as well as many others. So, and even then when the CSC told them, well, you're performing duties as a fire specialist and you'll be compensated thereby, they didn't do anything even at that point to try and say, well, then we should at least be skipped over everyone else and elevated to the position and instantly promoted as fire specialists, because that statute existed at the time that they were before the CSC regarding the permanent appointment of those who were formerly temporarily appointed. Not that that's what occurred in the petitioner's case, but they could have at least raised the issue then, and there was no reason they could not have. So in terms,
let me ask this: how does one satisfy the requirements of 72-107? What type of action is required in order to occupy a position for a period of 5 years and be eligible to be promoted under 72-107? Because you're not suggesting that we strike down 72-107, right?
no, Your Honor, it wouldn't be necessary because it doesn't apply to petitioners here at all.
Assuming that it does, and Attorney Terlai is able to overcome the hurdles of the procedural hurdles here. And we have to determine, what does occupy mean in reference to 72-107? How does one satisfy, how does a firefighter become eligible under 72? It must exist for some reason.
Certainly, Your Honor. And to answer the question, it just by virtue of a plain reading of the language of that law, the employee who has occupied the position on a temporary basis for more than 5 years, and this shall be deemed to be promoted.
How does that initiate? What is the temporary basis? What documentation, what action needs to go into effect or be effective in order to be temporarily appointed to this position in order for the firefighter to occupy?
A formal temporary appointment by the supervisory authority or whatever the hiring authority is that is authorized to make either a detail or a temporary appointment to a position, because then you would, the employer acknowledges that this is happening.
How do you
And is on full
reconcile that
notice.
with 4 GCA 4117? How is that possible if 4 GCA 4117 is not to be violated? that you can't temporarily assign or detail an employee for more than 90 days. 180 if you get the Director of Department Administration's authorization. So how do you accomplish that?
Well, okay, 72107, when you look at it, you can infer that it was meant to remedy something that was never done properly under 4117 to allow, and apparently it must be there to address people who have been in temporarily appointed, formally temporarily appointed to positions for much longer than the 90 days or 180 days. Because if it's come to the point of 5 years, then they're saying, well, they're just going to go ahead and promote them because they've been doing it for that long, but they were formally appointed to begin with. And that should have been remedied by a job reclassification, or the fact that those appointments will be nullified because they were done in derogation of law by surpassing the 90 or 180 days, the case may be. But here, to answer the court's question.
If the circumstances, if the fire chief says that in order to, it is told that in order to comply with 72107, I have to make a temporary appointment so that the firefighter one can perform these additional duties, and we don't have the money, the FTE, to have these additional personnel that can perform these additional duties. But at the same time, is told that you cannot appoint anyone to a temporary appointment or a detail appointment without violating the statute under 4117. So I'm just at a quandary. What does occupy mean when you can't execute a GG1 that says I'm temporarily appointing you to this position for 5 years?
Not for 5 years, but like I was saying, that's why 72107, it's very apparent that this is to remedy a past error, because people were, in order to qualify under this, must have been appointed for longer. And also it could be argued that this is the specific statute that would govern the general, being 4117. I know petitioners have rejected the application of that statute to their circumstance. And it says it right here in the title, rendering appointments permanent, Your Honor. You can't render something permanent as an appointment if there is no appointment to begin with. It does not, the statute doesn't say that anyone who performs the duties for 5 years will be automatically promoted. And you can't perform duties on a temporary basis, because that just doesn't, that language doesn't apply. It doesn't make sense when referring to performing duties. An appointment on a temporary basis does, an act by the hiring authority to detail them or actually appoint them.
So shouldn't it have some language to say that notwithstanding 4117, the department head can appoint an employee on a temporary basis in excess of 180 days? Shouldn't there be some type of triggering language that will authorize this? Because I think you have then the circumstance of the facts that we have in front of us, where the two firefighters here were performing fire service specialist duties in excess of 5 years, and the department has, number one, chosen not to compensate them for this additional, because there's no GG1 that will authorize payroll to pay them for the excess service. And so, but you're saying, well, despite us having this expectation, you have to object in order for us to then be required to pay you. It just seems that there are equities here that are called into question should that issue be reached.
Understood, Your Honor. And yes, I would agree that it would be ideal if 72107 did acknowledge and attempt to reconcile itself with 4117. That's not what happened here. And again, it brings into the question, as the court kind of hinted at initially, as to the legitimacy of 72107 itself to be able to circumvent the competitive hiring process. Because even given the perceived inequities, the petitioners place themselves in this position. Like I said, Your Honor, they could have refused to do those duties until they were properly compensated, or put in a position where they would be mandated to perform the duties and be properly compensated for them. But they didn't do that. They didn't seek a job classification. Well, they did seek a promotion to fire captain initially, but that was way beyond the pale in terms of, because they weren't on all fours of that position in terms of duties they were in fact performing, but they were in fact more than those of firefighter one. But they didn't pursue those avenues sufficiently or at all, really, except for in hindsight and retrospect, to be able to resolve the inequities in a way that the court is now perceiving them. And they were in fact compensated.
You seem to suggest that the absurd result that would occur under this situation is employees would do sort of self-promotion and just do the work without any temporary detail assignment into that position. But that's not really the facts of this case, right? I mean, here they were actually performing duties that were requested of them. Although they're, you know, in your position, you're saying they weren't temporarily appointed, or they weren't appointed to that position even temporarily.
Your Honor, I am not suggesting that they were performing duties surreptitiously and without the knowledge of their employer. I wouldn't even venture to suggest that, because I sincerely doubt that that was what was happening. But it doesn't.
That was what you suggested would make why it's there was an absurd result that could occur if it was interpreted in the manner that was suggested by the petitioner.
That was suggested in the lower court by another counsel with my office. And in terms of general application of the argument, I would stand by that, Your Honor. That can't be the measure by which we seek to properly compensate others. They can't create their own job. But I'm not suggesting that that was necessarily the case here. I don't know for a fact, but I have no reason to assume that they were not conducting those duties without permission. Another problem for the petitioners in this case, and why the court should affirm, is not just because of the problems with the application of 72-107 to their circumstances, but also because they resign, as the court pointed out. Now, whereas counsel like to characterize this euphemistically as a break in service, they resign. And that is an open and unambiguous waiver of the right to continue to pursue the issue at the administrative level, like they should have. Even if they did get rehired, and they were rehired to different positions than they were in when they left. So it doesn't make sense to be able to come back and promote them from a position that they are not in anymore. Also, just to address the petitioner's argument that somehow the respondents and real party and interest are bound by judicial admissions, I hope the court would give this no more than cursory analysis. I think it's very clear, even as the trial court pointed out, that the supposed admissions that were made by respondent and real party and interest were only quasi admissions, not judicial admissions that are considered binding. There were also admissions regarding issues of legal opinion and fact, whether or not, according to 72-107, the petitioners occupied the position of fire specialist, whereas in other portions in all pleadings and the motions to follow, which continued, were such that there were other contradictory responses that the respondent and real party interest always continually denied that 72-107 applies. And Your Honors, I would rest on that. We ask that the court affirm the lower court's holding in this case. And unless the court has any other questions of myself, I would concede the floor. And thank you.
Thank you, Mr. Canto. If there are no questions for Deputy Attorney General Canto, I will ask Attorney Terlahi. You have a few minutes
Yes.
to complete your rebuttal.
Yes, thank you, Your Honor. What's important in this case, as you hear from the government's position, is that the government never denies that it put the employees in a particular position to perform duties above and beyond the positions that they were hired for. In this particular case, GFD never denied that they appointed firefighters Nicolas and Sablon to the Fire Prevention Bureau and required that they perform the duties of fire specialists for more than 5 years. In fact, the Guam Fire Department had them perform duties as fire specialists from 2001 through 2008. At best, the public policy mandates that the court declined to award the government for its bad conduct, especially in this case, where the government has denied its obligation to the employees for a 20-year period. The employees have continually requested that the Guam Fire Department abide by its obligations imposed by law. And at every juncture, the government has placed obstacles before it. Now, the government sets forth that the employees waited too long to argue. Well, the employees made a complaint initially to their supervisors, and it led to a desk audit in 2005. Yes, albeit 4 years, but following those 4 years, they continued to perform duties for another 4 years through 2008. And what the government's position in this case is simply that they should not be held responsible for employees who perform duties that are required of them and in contravention of Guam law. Guam Fire Department was fully aware of its obligations not to temporarily assign employees to positions that are outside of their employment. They should not be rewarded. Public policy mandates that the court impose equity and award the firefighters what is imposed on DOA under the statute, and that's promotion to the fire specialist position. Your Honor, I believe I am out of time.
All right. Thank you, Attorney Terlahi. Thank you, Deputy Attorney General Canto. At this time, the court will take the arguments under advisement. We thank you for your presentation, and the court stands adjourned.
Sedus Masi, Your Honor.
Thank you, councils.